I stood in my driveway in Phoenix, Arizona, staring at the certified letter that had just been delivered. Feeling my blood pressure rise with every word, I read on the official HOA letterhead demanding that I submit all potential tenant applications to their screening committee for approval before I could rent out my investment property. My name is Frank Vanderbilt, and I had owned this 3-bedroom house in the Saguaro Springs subdivision for 8 years. I lived in a different property across town and had been successfully renting this place out for the past 5 years without a single issue. My tenants paid on time, maintained the yard, and never caused problems. But apparently, that wasn't good enough for Brenda Hutchinson, the newly elected HOA president who had decided to make everyone's life miserable with her endless power trips. The letter was 3 pages long, filled with pseudo-legal language about community standards and protecting property values and mandatory compliance procedures. The key demand was buried in the second paragraph. All homeowners who wish to rent their properties must submit tenant applications to the HOA board for screening and approval at least 30 days before any lease agreement could be signed. There would be a $200 processing fee per application, and the board reserved the right to reject any applicant they deemed unsuitable. I crumpled the letter in my fist and immediately pulled out my phone to call my real estate attorney, Marcus Chen, who had helped me with the purchase of both my properties. He answered on the 3rd ring. "Marcus, it's Frank. I need you to look at something the HOA just sent me. They're claiming they can force me to screen my tenants through them." "Send it over," he said. "But off the top of my head, that sounds like complete nonsense. HOAs can have reasonable rental restrictions, but they can't insert themselves into the landlord-tenant relationship like that unless it's explicitly stated in the CC and Articles." I pulled up my email on my phone while still holding the letter. I'm scanning it now. My current tenant's lease is up in 2 months, and they already told me they want to renew. I'm not paying the HOA $200 to approve people who have been model tenants for 3 years. "Don't do anything until I review this," Marcus advised, "and pull out your CC and Articles too. We need to see what authority they actually have versus what they're claiming to have." After I hung up, I went inside and pulled out the thick binder containing all my HOA documents from when I purchased the property. The covenants, conditions, and restrictions were dated from 2008 when the subdivision was first developed. I flipped through the rental section, which was only 2 paragraphs long. It stated that homeowners could rent their properties and must ensure tenants followed all HOA rules. That was it. Nothing about screening, nothing about approval processes, nothing about fees. My phone rang 20 minutes later. It was Marcus. "Frank, this letter is a joke. There's nothing in your CC and Articles that gives them this authority. They can't just make up new rules that contradict or go beyond what's in the governing documents. The CC and Articles would need to be formally amended, which requires a vote of the membership, usually at least 67% approval. So what do I do? Write them back. Cite the specific section of the CC and Articles that governs rentals, and politely but firmly tell them you'll be conducting your own tenant screening as is your legal right as a property owner. Keep it professional. Don't give them any ammunition to claim you're being hostile or uncooperative." I spent the next hour crafting a response letter. I kept it factual, referenced the CC and R section word for word, and stated clearly that I would continue to screen and select my own tenants according to federal and state fair housing laws. I sent it via certified mail the next morning. 3 days later, my phone rang from an unknown number. I answered it. "Is this Frank Vanderbilt?" a sharp, nasal voice demanded, speaking. "This is Brenda Hutchinson, president of the Saguaro Springs HOA board. I received your letter and I have to say I'm very disappointed in your attitude." I took a deep breath. My attitude is that I'm following the CC and Articles as written. There's no provision for the screening process you're trying to implement. "That's where you're wrong," she snapped. "The board has the authority to create and enforce rules that protect the community. It's right there in Section 12, subsection C of the CC and Articles. The board may adopt reasonable rules and regulations concerning the use of properties." I had the binder open in front of me. "I'm looking at that section right now, Brenda. It refers to things like noise regulations, parking rules, and architectural guidelines. It doesn't give you the power to interfere with private property rental agreements." "We're not interfering. We're protecting property values. You know what happens when bad tenants move in. They bring down the whole neighborhood. I've had the same tenants for 3 years. They're excellent. They take better care of the property than some of the homeowners who actually live here." "That's not the point," Brenda said, her voice rising. "The point is that we need oversight. We need to know who's living in our community. Just last week, someone's tenant parked a commercial vehicle on the street overnight. That's unacceptable. Then you cite them for the parking violation according to the rules that actually exist in the CC and Articles. You don't create a whole new screening bureaucracy that isn't authorized. If you don't comply with the board's directive, we'll have no choice but to fine you." "For what?" I asked. "I'm not violating any rule that actually exists. For failure to comply with board directives. That's a fine of $100 per day until you come into compliance." I felt my jaw clench. "Brenda, I'm telling you right now, that's not legally enforceable. You can't fine me for not following a made-up rule." "We'll see about that," she said coldly. "You have 2 weeks to submit your renewal tenant application for board review, or the fines start. And by the way, since your current tenants will be renewing, they'll need to go through the full screening process too. We need employment verification, credit reports, criminal background checks, personal references, and a written statement about their lifestyle and habits." "That's insane. They've already been vetted. They've lived there for 3 years without any issues. New policy applies to everyone. No exceptions." She hung up before I could respond. I immediately called Marcus back and relayed the entire conversation. "She's bluffing," he said. "Or she's so ignorant of the law that she actually believes she has this authority. Either way, you don't comply. If they try to fine you, we'll fight it, document everything, keep records of all communications. This is going to get ugly before it gets better." He was right. 2 weeks later, another certified letter arrived. This one informed me that I was being fined $100 per day starting immediately for failure to comply with mandatory tenant screening procedures. The letter included an invoice for the first week, $700. I didn't pay it. 4 days after that, I got a violation notice placed on my tenant's front door, claiming the property was in violation of community standards for harboring unapproved occupants. My tenant, a woman named Sarah Martinez who worked as a pediatric nurse, called me in tears. "Frank, what's going on? The HOA put this horrible notice on my door. My neighbors are looking at me like I'm some kind of criminal. I pay my rent on time every month. I keep the yard perfect. I don't understand what I did wrong." "You didn't do anything wrong, Sarah. The HOA is trying to implement a policy they don't have the legal authority to enforce. I'm fighting this. Don't worry about the notice. You're not in violation of anything. But it says if we don't vacate within 30 days, they'll pursue legal action. Frank, I don't want to move. My kids go to school right around the corner. This is our home. You're not going anywhere. They can't evict you. They have no legal standing to do that. Only I can terminate your lease, and I'm not going to do that. In fact, I'd like you to sign a new 2-year lease if you're willing. I'll even knock $50 off the monthly rent to compensate you for this hassle." That seemed to calm her down. We scheduled a time for the following weekend to sign the new lease agreement. The next day, I received a phone call from a law firm, Pemberton, Walsh and Associates. The woman on the phone identified herself as Jennifer Pemberton, attorney for the Saguaro Springs HOA. "Mr. Vanderbilt, I'm calling to inform you that if you don't comply with the board's tenant screening requirements and pay the outstanding fines, which now total $1,400, we'll be filing a lien against your property and pursuing legal action." Miss Pemberton, have you actually reviewed the CC and Articles for this HOA? Of course I have. Then you know there's no provision that authorizes this screening process. The board is making up rules that don't exist in the governing documents. The board has broad discretionary authority to adopt rules that protect the community, not rules that fundamentally alter property rights, not rules that aren't grounded in the actual CC and Articles. You know this. If you file that lien, it'll be fraudulent and you'll be exposing both yourself and your clients to liability. There was a pause. "Mr. Vanderbilt, I'm trying to avoid litigation here." "So am I. Tell your client to back off. I'm not doing anything wrong. I'm renting my property according to the rules that were in place when I bought it. If the HOA wants to change those rules, they need to properly amend the CC and Articles, which requires a membership vote. They can't just declare new rules by fiat. The board disagrees with your interpretation." "Then we'll let a judge decide." She hung up. I called Marcus again. "They've lawyered up, Pemberton, Walsh and Associates." "I know them," Marcus said. "Jennifer Pemberton does a lot of HOA work. She's competent, which means she probably knows her client doesn't have a case, but she'll string them along for the billable hours. Here's what we do. I'll draft a cease and desist letter explaining exactly why their position is legally unsound. If they proceed after that, we can argue they're acting in bad faith, which could get us attorney's fees when we win. When we win, not if. Frank, this is one of the clearest cases I've seen. They have no authority for what they're trying to do. The only question is how much money and stress they'll put you through before they figure it out." Marcus sent the cease and desist letter 3 days later. It was 5 pages of detailed legal analysis, citing specific case law from Arizona courts about HOA authority and the limits thereof. It concluded with a demand that the HOA immediately rescind the fine notices, remove the violation notice from the property, and cease all attempts to interfere with my legal rental of the property. The response came not from their attorney, but from Brenda directly. She showed up at my house unannounced on a Saturday morning. I opened the door to find her standing on my porch, arms crossed, lips pursed. She was exactly what I'd imagined. Mid-50s, severe haircut, dressed like she was heading to a country club board meeting. "We need to talk," she announced. "I have nothing to say to you, Brenda. All communications should go through my attorney at this point." "Oh, so you're too good to talk to me. Too important." "It's not about that. It's about the fact that we have a legal dispute and everything needs to be documented." "This isn't a legal dispute. This is you being selfish and stubborn. Do you know how hard I work to keep this community nice? I volunteer my time. I get nothing for this. And people like you come along and undermine everything we're trying to do. What you're trying to do is illegal, Brenda. You can't just make up rules that aren't in the CC and Articles. We're not making up anything. We're exercising our authority to protect property values. Do you know what happens to property values when neighborhoods fill up with renters? They go down. It's a fact. First of all, that's not a fact. Second, even if it were true, you can't ban rentals or create restrictions that aren't in the governing documents. I'm not banning rentals. I'm just saying they need to be approved, which you have no authority to require. She stepped closer, jabbing her finger toward my chest. You think you're so smart with your lawyer, but you know what? You still have to live in this community, you still have to follow our rules, and if you keep fighting us, we will make your life hell. Every little thing that property does wrong, we'll cite it. Every blade of grass that's too long, every spot on the driveway, every window that needs cleaning. You'll be drowning in violation notices. Are you seriously threatening to harass me with frivolous citations? I'm telling you there will be consequences for not being a team player. Get off my porch, Brenda, right now. You're making a mistake, she said, but she backed away. A big mistake. I closed the door and immediately called Marcus to relay what had just happened. That was incredibly stupid of her, he said. She just admitted she's planning to retaliate against you for exercising your legal rights. Write down everything she said, word for word, while it's fresh in your memory. If they do start citing you for frivolous violations, that's harassment and we can sue for that separately. I spent the next hour writing out a detailed account of the conversation. Then I emailed it to Marcus and saved copies in multiple places. True to her word, Brenda launched a campaign of harassment. Over the next 2 weeks, I received 8 violation notices on the rental property. The grass was supposedly a 1/4 inch too long. There was a small oil stain on the driveway that needed pressure washing. The house numbers on the mailbox were faded and illegible, even though they were perfectly clear. The backyard fence had a board that was slightly discolored and needed to be replaced. One notice claimed there was excessive noise coming from the property at 10 in the morning on a Tuesday, which was ridiculous since Sarah worked night shifts and was sleeping at that time, and her kids were at school. Each violation notice came with a $50 fine if not corrected within 5 days. Sarah was beside herself. Frank, I don't know what to do. I mowed the lawn 3 days ago. I pressure washed the driveway last month. These complaints are crazy. Don't do anything, I told her. Don't pay any fines. Don't respond to the notices. Document everything with photos and timestamps. We're building a harassment case. I also installed security cameras around the property, front and back, to have video evidence of the property's actual condition and to catch anyone from the HOA snooping around. The cameras proved invaluable. 2 days after installation, they caught Brenda herself walking through the side yard, taking photos of the house from multiple angles. She even tried to peek into the windows. I had her dead to rights for trespassing. Marcus loved it. This is gold. She's unhinged. We can use this to show a pattern of harassment and abuse of authority. The fines kept accumulating. According to the HOA's accounting, I now owed over $4,000 in various fines and late fees. They sent another letter threatening to place a lien on the property if the balance wasn't paid within 15 days. Let them try, Marcus said. The second they file that lien, we file suit. We'll go for attorney's fees, damages for harassment, and an injunction preventing them from continuing this behavior. I trusted Marcus, but the stress was getting to me. I wasn't sleeping well. Every time my phone rang or the mail came, I tensed up, expecting another attack from Brenda and her board. Then things escalated in a way I didn't expect. I got a call from Sarah late on a Thursday night. She was crying, barely coherent. Frank, they called Child Protective Services on me. CPS showed up at my door saying they received a report that my children were being neglected. that the house was unsafe. They came inside. They looked at everything. Thank God the house was clean and the kids were fine, but Frank, someone tried to get my kids taken away from me. My hands were shaking. Sarah, I'm so sorry. Did CPS say who made the report? They wouldn't tell me. They said it was anonymous, but I know it was the HOA. It had to be. This started right when all the violation notices started. I'm going to end this, I told her. I promise you, this is going to end. I called Marcus at home, not caring that it was almost 11 at night. They called CPS on my tenant. They're trying to get her kids taken away to force her to move out. Marcus was silent for a moment. That's beyond harassment. If we can prove the HOA or Brenda made that call, that's filing a false report, which is a crime. It might even be considered criminal harassment or witness intimidation since Sarah's a witness to their abuse of authority. How do we prove it? We might not be able to prove it directly, but we can establish a pattern. We file a lawsuit first thing Monday morning. We're going for an emergency injunction to stop all enforcement actions. We're seeking damages, and we're going to request that the court order the HOA to produce all communications between board members for the past 3 months. If there's evidence, we'll find it. Do it. That weekend was torture. I kept in close contact with Sarah, making sure she and her kids were okay. I reviewed all the evidence we'd collected. The letters, the notices, the videos, my written account of Brenda's threat, everything. Monday morning, Marcus filed a complaint in Maricopa County Superior Court. The lawsuit named the HOA, Brenda Hutchinson individually, and 3 other board members. We alleged abuse of authority, harassment, violation of property rights, and intentional infliction of emotional distress. We asked for $50,000 in damages, attorney's fees, and an immediate injunction. The court scheduled an emergency hearing for that Wednesday. Tuesday afternoon, I got a call from a number I didn't recognize. Against my better judgment, I answered. Mr. Vanderbilt, this is Carl Rodriguez. I'm on the HOA board. I'm calling you without the knowledge of Brenda or the other board members because I think you should know something. I'm listening. I didn't support any of this tenant screening stuff. I voted against it when Brenda proposed it. She pushed it through anyway with her voting block, but there's something worse. At our last board meeting, which was last Wednesday, Brenda told us she'd taken care of the tenant problem. And when one of the other board members asked what she meant, she said she'd made a call to the authorities about unsafe living conditions at the property. She was laughing about it. My blood went cold. She admitted to calling CPS. Yes. I didn't know what CPS was until I looked it up later. Mr. Vanderbilt, I have children. What she did is unconscionable. I'm resigning from the board and I'm willing to testify about what she said if it helps your case. Carl, I need you to write down everything you remember from that meeting, every word she said. Can you do that? I already did. I'll email it to you today, and Mr. Vanderbilt, I'm sorry. I should have spoken up sooner. Carl's email arrived an hour later. It was a detailed 2-page account of the board meeting, including direct quotes from Brenda bragging about calling CPS and how it would solve the problem of stubborn tenants who don't know their place. I forwarded it immediately to Marcus with the subject line, "Smoking gun." Marcus called me within minutes. This changes everything. I'm amending the complaint to add the CPS call, and I'm requesting criminal charges be filed. This is filing a false report with a government agency, which is a Class 1 misdemeanor in Arizona. With the evidence of intent and premeditation and the harm caused, the county attorney's office will be interested. Wednesday's hearing was intense. We were in front of Judge Patricia Meadows, a no-nonsense jurist in her early 60s. The HOA's attorney, Jennifer Pemberton, showed up with Brenda and 2 other board members. Marcus presented our case methodically. He entered all the letters, the violation notices, the video of Brenda trespassing, my written account of her threats, and Carl Rodriguez's statement about the board meeting. He called Carl as a witness via phone, and Carl repeated under oath what Brenda had said about calling CPS. Judge Meadows looked at Brenda. "Miss Hutchinson, did you place a call to Child Protective Services regarding the tenant at Mr. Vanderbilt's property?" Brenda's face went red. "I had concerns about the welfare of children in the community." "That's not what I asked. Did you place the call?" "I may have expressed concerns to various agencies." "Yes or no, Miss Hutchinson?" "Yes, but I had good reason. Did you have personal knowledge of abuse or neglect occurring?" Brenda stammered. "I had seen the children outside unsupervised." Judge Meadows turned to me. "Mr. Vanderbilt, do you have evidence contradicting this claim?" Marcus stood. "Your Honor, we have security camera footage from the relevant time period. The children are never outside unsupervised. They're either with their mother or with an adult babysitter. We also have CPS's report, which found no evidence of neglect or unsafe conditions whatsoever." The judge reviewed the CPS report, which we'd subpoenaed. Her expression grew darker as she read. "This report indicates the home was clean, well-maintained, and the children were healthy, well-fed, and properly supervised. It also notes that the reporting party provided no specific information about the alleged neglect, which is unusual for a genuine concern." She looked at Brenda. "Miss Hutchinson, it appears you filed a false report to harass a tenant you wanted removed from the community. Is that accurate?" "No, I was concerned about the neighborhood. Your concern about property values is not a valid reason to weaponize Child Protective Services." Judge Meadows turned to Marcus. "I'm granting your injunction. The HOA is hereby ordered to cease all enforcement actions against Mr. Vanderbilt's property immediately. All fines are rescinded. The violation notices are null and void. The HOA is prohibited from contacting Mr. Vanderbilt or his tenant, except through proper legal channels regarding legitimate violations of the actual CC and Articus." She looked at Brenda again. "Furthermore, I'm referring this matter to the Maricopa County Attorney's Office for investigation of possible criminal charges related to the false CPS report. Making a false report to a child welfare agency is a serious offense, Miss Hutchinson. It wastes government resources and traumatizes families." Jennifer Pemberton stood up. "Your Honor, my client was acting in what she believed was good faith. Counsel, your client bragged about making the call to solve a problem. That's in the written statement of a board member. That's not good faith. That's malicious." Judge Meadows signed the injunction order. "We'll have a full hearing on damages in 60 days. I suggest your clients consider settlement." We walked out of the courthouse into the bright Arizona sun. I felt lighter than I had in weeks. "That went better than I expected," Marcus said. "Judges hate it when people abuse the system to harass others, and they really hate it when people involve children for vindictive purposes. What happens now? The county attorney will investigate. If they charge her, she could face fines, probation, even jail time, though that's less likely for a first offense. More importantly for you, this strengthens your civil case enormously. The HOA will want to settle. They're liable for her actions since she was acting in her capacity as board president. I don't want their money, Marcus. I just want them to leave me alone. You're going to get both, trust me. Over the next week, things happened fast." The Arizona Republic ran a story about the case with the headline, "HOA President Accused of False CPS Report to Remove Tenant." It got picked up by local TV stations. Suddenly, Brenda Hutchinson was the poster child for HOA abuse. Other homeowners in Saguaro Springs started coming forward with their own stories of Brenda's overreach. One couple said she'd fined them repeatedly for having a vegetable garden in their backyard, even though gardens were explicitly allowed in the CC and Articles. Another homeowner said Brenda had tried to force him to remove solar panels that were legally installed with all proper permits. The HOA's attorney called Marcus to discuss settlement. The offer was substantial: full rescission of all fines and fees, reimbursement of my attorney's fees, $15,000 in damages, and Brenda's resignation from the board. Tell them $25,000 and a written apology to Sarah Martinez, I said. And I want a formal amendment to the CC and Articles, clarifying that homeowners have the right to rent their properties without HOA screening or approval. They accepted. The Maricopa County Attorney's Office filed charges against Brenda 2 weeks later: 1 count of false reporting to a child welfare agency and 1 count of harassment. She pled no contest to both charges as part of a plea agreement. She was sentenced to 2 years of probation, 100 hours of community service, a fine of $2,000, and mandatory anger management counseling. The day the settlement was finalized, I drove over to the rental property to meet with Sarah. She was in the front yard, planting flowers along the walkway. "It's over," I told her. "Brenda's resigned, she's been charged criminally, and the HOA can't bother us anymore." Sarah stood up, brushing dirt from her knees. She had tears in her eyes. "Frank, I don't know how to thank you. When they called CPS, I was terrified. I thought I might lose my kids over some crazy neighbor politics. You never should have been put in that position. I'm sorry you went through that. Are we still okay to stay? I know this has been a nightmare for you. Are you kidding? You're my favorite tenant ever. You just signed a 2-year lease. I'm hoping you'll stay even longer than that." She hugged me, and I let her, even though I'm usually not much of a hugger. The CC and Articles were formally amended at a special membership meeting 2 months later. The amendment passed with 92% approval. It explicitly stated that homeowners had the right to rent their properties and to screen and select their own tenants according to federal and state law. The HOA could not require pre-approval of tenants, could not charge screening fees, and could not discriminate against renters in the enforcement of community rules. A new board was elected. Carl Rodriguez became president. He called me to apologize personally for not standing up to Brenda sooner. "I learned something from all this," he said. "Silence in the face of injustice makes you complicit. I should have fought harder from the beginning." "You came through when it mattered," I told him. "That counts for something." Marcus and I celebrated the final settlement over dinner at a steakhouse in Scottsdale. He ordered an expensive bottle of wine. "To victory," he said, raising his glass. "To standing up for property rights," I replied. "You know what I love about this case?" Marcus said. "It's not just that we won. It's that we established precedent. Other HOAs in Arizona are going to think twice before pulling this kind of nonsense. Your case has been cited in 3 other lawsuits already. Good. Maybe it'll save someone else from going through what I went through." 6 months later, Sarah's kids were playing in the front yard when I stopped by to fix a leaky faucet. They waved at me and went back to their game. The house looked perfect: fresh paint on the trim, flowers blooming in the beds, grass green and neatly trimmed. A man walking his dog stopped on the sidewalk. "You the owner?" he asked. "Yes, sir." "I wanted to shake your hand. I'm Tom, I live 2 streets over. What you did, standing up to that crazy HOA board, that took guts." My wife and I were thinking about renting out our house and moving to Flagstaff for a couple years for her job, but we were afraid the HOA would make it impossible. After your case, we're going to do it. Just know your rights, I told him. Read your CC and Articles. Don't let anyone bully you into giving up your property rights. Damn straight, he said and walked on. I finished fixing the faucet and was packing up my tools when Sarah came home from her shift at the hospital. She looked exhausted but happy. Hey Frank, I saw the faucets fixed. You're a lifesaver. Just part of the service. How's work? Crazy busy but good. Hey, I've been meaning to tell you my brother's moving to Phoenix in a few months. He's looking for a place to rent. You wouldn't happen to know of anything available, would you? Not at the moment, but give me his contact info. I keep my ear to the ground. If I hear of something, I'll pass it along. You're the best landlord ever, you know that? I just believe in treating people with respect. It's not that complicated. As I drove home that evening, I thought about everything that had happened over the past year. The stress, the anger, the legal battles, the fear that I might lose my investment property or bankrupt myself in legal fees fighting a petty tyrant with too much time on her hands. But I also thought about what I'd learned. I'd learned that standing up for yourself matters, even when it's hard. I'd learned that there are good people like Carl Rodriguez and Marcus Chen who will stand with you when you're in the right. I'd learned that the legal system, for all its flaws, still protects property rights and individual liberty when someone has the courage to invoke it. Most importantly, I'd learned that people like Brenda Hutchinson only have the power you give them. The moment you refuse to be intimidated, the moment you stand on solid legal ground and refuse to budge, their power evaporates. They're bullies, and like all bullies, they fold when someone punches back. I never saw Brenda again after the court hearings. I heard through the neighborhood grapevine that she'd moved out of Saguaro Springs entirely, too embarrassed to face the neighbors after everything became public. Her house sold quickly, and a young family moved in with 3 little kids who played in the yard every evening. The new HOA board under Carl's leadership was night and day different. They focused on actual community improvement, organizing neighborhood barbecues, negotiating better rates for common area maintenance, and updating the playground equipment at the community park. They enforced rules that actually existed in the CC and Articles, and did so fairly and evenly, without targeting anyone. Property values in Saguaro Springs actually increased after the whole debacle, which I found ironic given Brenda's obsession with protecting values through authoritarian control. Turned out people preferred living in a community governed by reasonable people who respected individual rights. A year after the settlement, I attended the HOA annual meeting for the first time in years. Carl gave a report on the board's activities and the community's finances. Everything was running smoothly. When he opened the floor for questions and comments, an older gentleman stood up. I just want to say, this is the best the HOA has run in the 15 years I've lived here. We finally have a board that serves the community instead of lording over it. Thank you. There was applause. Carl smiled. We learned some hard lessons about what happens when people abuse authority. We're committed to making sure that never happens again. After the meeting, several homeowners came up to me to shake my hand and thank me for fighting back against Brenda's overreach. One woman told me she'd been planning to sell her house because the HOA had become so oppressive, but now she was staying. "You gave us our neighborhood back," she said. "I didn't feel like a hero. I'd just been a guy trying to protect his property rights and his tenant. But if my fight had made life better for other people too, then all the stress and legal fees had been worth it." Sarah's family ended up staying in the house for 4 more years. When her kids got older and they needed more space, I actually bought another property in the same neighborhood, a bigger place, and moved them into it at the same rent they'd been paying. They were the kind of tenants every landlord dreams of: responsible, communicative, respectful of the property. When they eventually bought their own house across town, Sarah cried as she handed me the keys on moving day. "You stood up for us when someone tried to destroy our family," she said. "I'll never forget that. You were worth fighting for," I told her. The rental market in Phoenix remained hot, and I never had trouble finding good tenants. Word got around that I was a fair landlord who treated tenants like human beings rather than revenue sources. I got referrals constantly. Marcus and I stayed in touch. He sent me a bottle of expensive scotch every year on the anniversary of our court victory. The card always said the same thing: to fighting the good fight. 5 years after the whole ordeal began, I was having lunch with a friend who worked in real estate development. He mentioned that he'd just been to a seminar on HOA governance and risk management. "They used your case as an example," he said. "The instructor talked about what happens when HOA boards exceed their authority and engage in harassment. Your case is literally in the training materials now for HOA board members and management companies." "Good," I said. "Maybe it'll prevent someone else from going through what I went through." The instructor said HOAs lose cases like yours 90% of the time when they go to court, but they keep trying the same nonsense because homeowners usually just give in rather than fight. You didn't give in. I couldn't. It wasn't just about me. It was about Sarah and her kids. It was about the principle that you can't just make up rules because you feel like it. Well, you cost that HOA about 80 grand in legal fees, settlement, and court costs. That's a pretty good deterrent. I smiled. I prefer to think of it as an expensive education. Looking back now, I can see how the whole experience changed me. Before Brenda's power trip, I'd been passive about HOA issues. I paid my dues, followed the rules, and didn't get involved. Now I understood that vigilance is the price of liberty, even in something as mundane as a homeowners association. I started attending HOA meetings regularly, not because I wanted to be on the board, but because I wanted to make sure no one else tried to turn the HOA into a personal fiefdom. I encouraged other homeowners to stay informed and engaged. Democracy, I learned, isn't just about presidential elections and Congress. It's also about showing up to boring Tuesday night meetings in a community center conference room to make sure the people running your HOA don't go crazy with power. The rental property that started the whole mess is still generating good income. The tenants who live there now are a retired couple who moved from Minnesota to escape the winters. They love the house, they love the neighborhood, and they never cause any problems. They also know the whole story of what happened with Brenda, and they think it's hilarious. "You stuck it to the HOA witch," the husband, Dave, said when I told them the story over beers one evening. "Good for you. We left our old neighborhood in Minneapolis because the HOA there was run by tyrants. It's nice to know there are still places where sanity prevails." His wife Linda added, "And landlords who actually care about their tenants. You could have just folded, moved Sarah out, found new tenants who weren't involved in the drama, but you fought for her. That's rare." "She deserved to be fought for," I said simply. As the years went by, the story of my fight with Brenda became local legend in Saguaro Springs. New residents would hear about it and seek me out to get the full story. I always told them the same thing: know your rights, stand your ground when you're in the right, and don't let petty tyrants intimidate you. The CC&R amendment I fought for remained in place, protecting homeowners' rental rights. Carl Rodriguez served as HOA president for 3 terms and then passed the torch to another reasonable, level-headed neighbor. The HOA became a model of good governance, focused on maintaining the community and serving homeowners rather than controlling them. I sometimes wonder what happened to Brenda. I heard she moved to Tucson, but I never verified it. Part of me hopes she learned something from the experience, that maybe the criminal charges and public humiliation taught her that you can't treat people like subjects in your personal kingdom. But honestly, people like that rarely change. They just find new venues for their authoritarian impulses. What matters is that her attempt to abuse power failed. The system worked. Property rights were protected. A good family wasn't destroyed by false accusations. And a community learned the difference between reasonable governance and tyrannical overreach. On quiet evenings, when I drive through Saguaro Springs and see families in their yards, kids playing, neighbors talking over fences, I feel a sense of satisfaction. This is what a community should be. People living their lives, respecting each other's space and rights, working together on common interests without anyone trying to dominate or control. The fight was worth it. Every stressful phone call, every dollar in legal fees, every sleepless night wondering if I'd made the right choice by standing my ground. It was all worth it because in the end, principle prevailed over petty tyranny. And that's a victory that echoes far beyond one rental property in Phoenix, Arizona. It's a reminder that individual rights matter, that property ownership means something, and that citizens don't have to bow to self-appointed authorities who abuse their power. I learned that sometimes the most important battles aren't fought on grand stages, but in county courthouses over seemingly mundane disputes about who has the right to rent their house without intrusive oversight. These small battles over small freedoms are what keep society free. Years from now, long after I've sold these properties and moved on to other investments, I'll remember the time I fought an HOA president who thought she could force me to screen my tenants through her personal approval process. I'll remember standing in court while a judge told that petty tyrant that she'd crossed the line. I'll remember Sarah's relief when her kids weren't taken away because of a malicious false report. And I'll remember that standing up for what's right, even when it's difficult and expensive and stressful, is always the correct choice. Because if people don't stand up to bullies, bullies win. And when bullies win, everyone loses their freedom a little bit at a time. That's the real story here. Not just about one man fighting one overzealous HOA president, but about the eternal struggle between those who want to control others and those who simply want to be left alone to live their lives and manage their property in peace. I won that struggle, not because I was special or heroic, but because I refused to give in and because I had good people like Marcus and Carl on my side. That's the lesson I hope others take from my experience. You're not alone when you stand up to injustice, and the law really does protect your rights if you're willing to fight for them. The sun was setting over the Saguaro Springs subdivision as I drove home that evening, painting the Arizona sky in brilliant oranges and purples. Somewhere in those houses were people living their lives, secure in their property rights, free from harassment by power-hungry board members. I'd played a small part in preserving that freedom, and that was enough. That was more than enough.